All right. Well, good morning. My name is Jean Tomasco. I'm the HR manager here at the diocese at ECCT. Prior to joining the diocese a couple of years ago, I was an employment lawyer for longer than I care to admit. Um, but let me share my screen, and I'll be going over kind of basic HR things, but also, um, okay, can everybody see that? Okay. I think I muted folks, but if you have questions as we go along, please feel free to put it in the chat. And also if I don't hear you or don't see you, just, unmute yourself and just say, I have a question. So, again, we lawyers love disclaimers. The presentation is for general informational purposes only. It's being recorded. As you know, it's not confidential. It's not legal advice, and there's no attorney-client relationship that's established. And the other thing I do want to mention, and it goes to the confidentiality, is, if you do have like a question or a particular issue, please don't use real employee names. And also, try to, if it's something that's really detailed and all that, feel free to contact me after the presentation, either by a phone call or, letting me know that, afterwards by email, and we can set up a time to talk. The first thing I just wanted to bring to people's attention, because not everybody is aware of this, but we do have a lot of resources in HR online. And if you go to the basic website, and I'll probably try to show you later, but I'm going to do it at the end of this so I don't mess up the presentation. But if you go to the first page and scroll down, there's a parish administration icon. Just click on that. And then there's a human resources icon. And when you click on that, you'll see there are 3 folders. One is articles, one is handbooks and sample policies, and the other is templates, forms, and checklists. And once you're in resources, you can search. So this is really a good resource, at least, to start with. I try to keep it updated and add things as we go along. And you may find something that's helpful there. You may still have questions, certainly give me a call, but there is a lot of information there, and I find that a lot of people are not aware of it. All right, in terms of what we're going to try to go through this morning is, kind of all stages of the employment process, the recruiting stage, job descriptions, policies, what you do with your files, some wage and hour things, time off, leaves of absence, performance and discipline, and termination of employment. I'm hoping we can cover most of that, if not all. And again, if you have questions as we go along, just be sure to, put it in the chat, although I'm not in the chat right now, or just, unmute yourself and ask a question. So in terms of the first thing you're going to do, you need to hire somebody, is put together a job posting. And obviously it should include the job title, whether it's a full-time or part-time position, whether it's going to be in person all the time, remote, full-time, or maybe something that's hybrid that can be in the office a few times, a few days a week, and then maybe work remotely other times. You want to include a job summary of the job duties. It can be briefer than what might actually be in a more in-depth job description. You can go over that if you interview with folks. And education versus qualifications, and give some thought to this as to what is actually your minimum requirement versus what you would like. Like what would be the unicorn? Gee, I want to hire somebody and I wish they had 10 years of experience. Well, you're probably not going to get that. So, just say 3 years of experience or whatever it might be. You can always, if you get people who are more qualified, who you like better, that's great. But if you put in like something like 10 years, you're going to lose a lot of applicants potentially. You want to include the equal employment opportunity statement, that you don't discriminate. Compensation, just to note that Connecticut has a relatively new law that employers with one or more employees must provide information pertaining to the wage range for the position. You don't have to put it in the job posting, but I think more and more people are kind of looking for that. And wage range is defined as the range of wages an employer anticipates relying on when setting wages for a position, including any applicable pay scale, previous determined range of wages for a position. It could be an actual range of wages for employees in comparable positions, your budgeted amount for the position. You could rely on something like salary.com or the Department of Labor, but you just have to have some reason as to why you established the range. And even if you don't put it in the job posting, you need to provide it to the applicant either on the earliest of their request, the applicant may ask you, or prior to or at the time you make an offer of employment. So again, you may want to include it in the job posting, and but you don't need to, but you do need to provide it if somebody asks or before they're at the time of employment. Benefits, you don't need to include. We'll talk about, what kinds of benefits you may be required to provide. But you may want to briefly mention them if it is a position that has benefits like medical or dental, and it might attract more applicants. But if the position isn't eligible for benefits, if it's, a part-time position that really doesn't meet the minimum requirements for any of the benefits, you probably don't want to mention them. All right. You've posted your job. So how do you find or attract people? One is just putting it in your church communications, word of mouth, letting people know, hey, we're looking for, an office administrator. And, if you know of anyone, post it on our website. And if you go to, the site and look at open positions, it allows you to put in your job posting. And also if you have a PDF, you can attach that. The way that works is I get a notice that somebody's put in a job request, and then I just look at it to make sure there's nothing either confusing or something you might want to change in terms of wording. And usually it's not, and I just approve it, and then it goes live. The Episcopal News Service, you can do a free posting on their site for, I think it goes for 30 days. It tends to be better, I think, for, higher positions where, like a music director or somebody, maybe a Christian education person, because that tends to be viewed by, I think, people like the rectors in the position or the wardens. But it doesn't hurt. It's free, and somebody may say, hey, I know somebody that this looks like a great job for them, and maybe encourage them to apply. You can also look at local schools and specialty schools as appropriate. There are some school sites. There's a college central network, which kind of covers the community colleges. And if you go to one of the community colleges and go to post a position, they generally will link you to that, and then you do an account and you post it. That's free. And there's also Handshake, which is for four-year colleges, and similar thing. If it's something where it's a little more specialized, you might want to send it to the seminaries, at least the local ones, Yale, Columbia, I always forget their name, but the old Hartford Seminary, I forget exactly what it is now. If it's a music director, you may want to send it to Hart School of Music. There is a way to post it through the Connecticut Department of Labor. Through a program called CT Hires. That's also free. I try to do, the lower cost things. Job boards, there are some specific to churches and nonprofits. I would say that most of them do charge a fee. It can be as low as $100, but that's still an expense. And you have to think about, really what's my return on investment? Because a lot of them are, nationwide. Some will even, put them all over the job boards. And you may get people that, for an administrative position, they're not planning to move to Connecticut, or they may not even apply. So it's kind of, is it worth it or not? ENS, the Episcopal News Service, also has a feature where you can pay and have your job highlighted. And again, I think you just need to determine, is it going to be worth it for me, and what's the position? And there's also the broader job boards, Indeed, Monster, LinkedIn. Most of those do have a free option, and again, you can upgrade and put a budget in. Those are good for, I think, administrative type positions. But if you're not getting a lot of applicants, that may be a way to go. Personally, I tend to kind of wait and see if I get a few applicants through the other sites before going to Indeed, or one of the other sites, because it seems you get a lot of people that I think just automatically apply like to every admin position, and they're not particularly qualified. Any questions on that? All right. Question that often comes up: can I hire a parishioner? Or what about the family member of a parishioner? There is, under the professional guidelines for ordained ministry, some guidelines on that. And it's generally not a good idea, and it's discouraged because it creates a dual relationship. Because usually the rector is going to be basically the employer. So it can be a dual relationship is when clergy attempt to relate to a person on two levels at the same time. So if you have somebody both where you're relating to them both personally as their pastor, and then professionally because they're your employee, that presents problems. So they diminish the effectiveness of the ministry if it's one of your parishioners. So you really we want to discourage hiring parishioners to serve in paid staff positions. But if that's unavoidable, the clergy and the lay leaders should understand all the risks to all relationships involved and take steps to mitigate that. It has to be ratified by the ministry. I'm sorry. Somebody have a question? Okay. It must be ratified by the vestry. There has to be guidelines for separation spelled out in the letter of agreement, and alternative arrangements have to be made for pastoral support of the employee, because you have that dual relationship and you don't want to serve as both the pastor and the supervisor. And same for, the clergy spouse, partners, family members from serving on a parish staff, it's the same issues potentially. And also, I'm sorry, can you mute yourself? Folks, I thought I muted everybody, but also, the other things to think about are potential conflicts of interest, the awkwardness if the person winds up not working out and you have to let them go. There's potential confidentiality issues, if somebody's having exposure to, your donations, your pledges, and you really want that to be a parishioner. So just to think about in that. Should I use an application form? You can, and it could be appropriate for positions like where you might not have a resume. Somebody might not have a resume, like a sexton or somebody. And it may also reveal gaps in employment that might not be readily available or readily apparent from a resume. And you want to get, if you are using an application, you want to get the person to sign off and say that. Can you guys mute yourself, please? I'm hearing background. You also, cons are there are limitations on what can be asked. You have to be careful as to what's on the application form. You can't ask about, dates of birth, anything like dates of attendance at college, because that could reveal age, and that's not allowed under Connecticut law. You cannot ask about the current compensation or salary history. That's part of that new law on wage disclosures. And there's limitations and very specific disclaimers you need to include if you ask about criminal history. If you do use an application, you'll want to include an employment at will statement saying, employment at will, you can terminate your employment, or we can terminate the employment at any time for any reason. And you want to have your applicant sign and say that it's accurate and complete. And remember, arrests are not proof of guilt and can be viewed as discriminatory. So all that stuff is best saved for the background check. There is a basic template if you do want to use an application on our website. Be careful about like searching the web for forms because they're not always in compliance with Connecticut law, and you may be, inadvertently including something you've been asked about. All right, so you get some candidates, you want to interview them. Who's going to interview them? You may want to have people interviewing the candidates, at least for kind of the final interview. It's just helpful to have somebody, it's hard to be asking questions and maybe jotting down a note and kind of interacting with the prospective employee all at the same time. The best questions to ask are those that are kind of tailored to job skills and training. Those could be things like, what interested you in this job? What about the posting appealed to you the most? This position requires great office skills, Microsoft Office. Do you have that skill or education if there's an education requirement? Open-ended questions are good, like tell me about your greatest accomplishment or about a time at work when something didn't go well and how you responded to that. So those are better questions to ask. You want to avoid questions that might elicit information about a protected classification. And that would be race, color, age, sex, including pregnancy, ancestry or nationality, sexual orientation, gender identity or expression, past or present history of a physical or mental disability, HIV or AIDS status, veteran status, marital status, familial status, genetic information. I'm not quite sure what question you'd be asking about that, or status of a victim of domestic violence. That's a new category that was recently added. Religion is also a protected category, but if a position requires ordination or membership in the Episcopal Church, that could be a bona fide occupational qualification. And if you look again on our website, there is a sample EEO policy that includes all of the protected classes. And also give the candidate time to ask questions. And a good candidate should have at least a couple questions prepared. And then, give them the process or the timing of the hiring process to the extent you can. It's great to do. They'll probably ask you anyway. And if you're not going to move forward with somebody, I think a brief email is really the way to go. Just, something saying we appreciate your taking the time to apply for the position and participate in the process, but we've decided to move forward with other candidates who, more closely match our needs. Bob, I saw you had a question before. I don't want to skip over it. If you still have your question.
Yeah, I was going to back a couple of slides ago.
Okay.
You mentioned about in the employment contract something that we needed to say in there, and I forget now what it was that kicked my memory.
Was it the employment at will or?
No, it was 2 slides ago when I put my hand up, I thought about it. Now I can't think about it.
Okay, well, if you think of it, sorry about that.
I think about it already.
I should
By
have
the
jumped
way,
on.
are these slides the same as what you had sent us?
Yes,
Yeah,
yes. So if you look them over and you have, the question, then just give me a call or shoot me an email.
Okay.
All right, the offer letter. You found your great candidate. You want to make an offer letter. What are things you need to include? This is a general statute that talks about what you need to advise not only your applicants, but your employees as well. So at the time of hiring, you need to let them know, hey, what are they going to be paid, the hours of employment, the wage payment schedule, like we pay, biweekly or every Friday, whatever it is. And, you also have to make available to them either in writing or, through a policy, a posted notice, any employment practices and policies or changes with regard to wages, vacation pay, sick leave, health and welfare benefits, and comparable matters. I will say if you have them, or if you're required to provide them, you're not, and I'll talk about this a little later, you're not required to provide vacation pay. you're not required to pay, provide health and welfare benefits, or if you do, make sure it's clear as to what the eligibility requirements are. If you're paying less frequently than bi-weekly, for example, if you pay twice a month, you actually need to obtain approval from the Connecticut Department of Labor to do that. They will routinely grant requests to pay 2 times a week. But you should go on their website. They have a sample form you can use and make that request. And they're usually pretty responsive. They won't approve anything over 1 month. And even 1 month, they're going to be looking to see that it's maybe a professional person that can be paid on that basis. And just note the requirement is to provide written notice of changes to compensation and things to your employees as well as your applicants. So if somebody's getting a raise, you want to put that in writing to that effect. The Department of Labor will say, hey, it can be, on a napkin. We don't really care, or a sticky note. And honestly, my husband came home with one on a sticky note one time. But I wouldn't recommend that. Put it in an email or something so you have a record of it and you can put it in their personnel file. Just a lot better to do that. All right, this is an area of great confusion, but the question is, gee, is this person non-exempt or exempt? Non-exempt employees are subject to minimum wage and overtime. And by the way, the general rule of thumb is that whichever law requirement, whether it's state or federal, it's the one that's most favorable to the employee that's gonna be the one you follow. So Connecticut, for example, has a minimum wage that's much higher, excuse me, than the federal minimum wage. And you only need to pay overtime for hours actually worked over 40 in a work week. And your work week should be set somewhere, like it starts at 12:01 on a Sunday and it ends at midnight on the following Saturday. But that should be spelled out so people know how the work week runs. And if they work on a weekend, they know which work week it falls into. Non-exempt employees need to keep accurate records of their time, including meal breaks. That's actually the employer's obligation, but generally the employees do that. It can be a basic like paper timesheet. They came in at this time, they took a lunch break at the next time they punched back in or came back in, and then they ended their day, at whatever time it is. So one big, I think, fallacy that you hear is like, well, if I just put them on a salary, then they're exempt. That is not true. It goes by job duties. If it's, more just basic office work, bookkeeping, that kind of thing, that does not make them exempt. It's got to be exempt duties, and I'll get into that in the next slide. On the other hand, so basically, if they're paid on a salary basis, they're not necessarily exempt. But the converse isn't true. If you start paying somebody on an hourly basis, and they might actually qualify for exempt, which you could do. You could even pay, as I always said, the CEO of the company could be on an hourly basis. That would make them non-exempt, and you would need to keep track of their hours and all that. Any questions on that? I'm going to move on to kind of what the exemptions are, but generally to be exempt from minimum wage, and I don't think minimum wage tends to be a problem with anybody, but it's more the timekeeping and record keeping. Be exempt has to fall under the job duties of the employee actually have to fall under an exception to the wage and hour law. And the most common you hear about are executive, administrative, and professional, which are also known as the white collar exceptions. The person must be paid on a salary basis, and there's an explanation in the statutes as to what that actually means. But you can't generally be making deductions. If they don't work, if they're on a salary basis for a week and they leave an hour or two early to go do something, you still pay them their full, salary for that week. There are some exceptions and deductions if they're taking FMLA time. You can, you don't have to pay them for that. If they're taking a full day absence for personal reasons, or if it's, the beginning or end of their employment and they start in the middle of the week, you can prorate it. But for the most part, you're not going to be making deductions for them. And they have to spend the majority of their time on exempt work. So, if you have maybe your office manager who once in a while does something that might fall within an exemption, but spends the majority of their time, doing data entry and typing and doing the newsletter or whatever, then they're not going to be exempt. The executive is the primary duty is managing the organization or a recognized subdivision of it. They have to have 2 or more full-time direct reports or the equivalent thereof, and they have to have the authority to hire or fire or whose recommendations on this are given weight. So that's the executive. Administrative, the primary duty is to do either performance of an office or non-manual work directly related to the management policies or general business operations of the employer or the employees, or you guys don't really have customers, parishioners, or performance of functions in the administration of a school system if you happen to have a school. But again, it's not the basic office work. It's something like me, for example. I don't have direct reports at this point, so I wouldn't fall within executive, but I would fall within administrative because I manage the human resources function for the diocese. So that's an example of that, but it customarily and regularly must exercise discretion and independent judgment on matters of significance. So it's not like, well, they have the discretion to, pick our supplier for office supplies. No, that's not going to be enough discretion. And they can't devote more than 20% of their time on activities not directly related to exempt work. Professionals, primary duties is, work requiring knowledge of an advanced type in a field of science or learning, customarily acquired after a prolonged course of specialized instruction. That could be a clergy person, that could be a lawyer, that kind of thing. And also work that is original and creative in character in a recognized field of artistic endeavor. Probably not going to come too often. Salary basis is a predetermined amount paid for each pay period, regardless of the number of hours worked, not subject to reduction because of variations in the quality or quantity of the work performance. It doesn't have to be paid for any work week in which they perform no work. If, for example, you happen to give vacation time, though, you can count it as, okay, you had 2 weeks of vacation. This counts as 1 week of your vacation. So you can't apply it to that, but you have to pay them their full salary for the week. If they wind up taking more time off than you would have liked or expected, as set forth in your policy, you still have to pay them for that week, but you could discipline them, talk to them about, hey, you're taking way too much time off and you're not getting your. Any questions on that? Okay, next stage. Whether somebody might be a contractor or employee. Sometimes folks are like, hey, it would just be easier if we just pay you as an employee, but it has to be, you have to look at different factors. And there is actually a new rule by the Federal Department of Labor saying, you look at the totality of the circumstances. And the 6 factors they look at is the opportunity for profit or loss, depending on the skill. So, it's got the common thing to think about is, somebody has their own business, the plumber that comes in or the cleaning service that comes in, they have their own business, they have the opportunity for profit or loss. What are they investing? Do they bring their own supplies? Or are you providing it? If you're providing that stuff, then they're most likely an employee. Is this an indefinite relationship? Or, hey, this person's just coming in to fix the stained glass window, they're a contractor, it's only going to last 30 days. How much a kind and degree of control? If you're supervising this employee, telling them what to do, they don't have the freedom to kind of do what they want within their knowledge, they're going to be an employee. If it's something that's really critical to the parish, like being the office manager, they would be an employee. Those are kind of the things to think about. If you misclassify someone as an employee, who's really an employee as an independent contractor, that can result in penalties, including payment of back wages, overtime, there may be record keeping violations, all that. So if it's all questionable, it's probably not worth it. And remember also that independent contractors are responsible for paying, their own employment taxes, both the employer part and the employee part. So if they're not doing that, do they have, liability insurance? You lose the protection of workers' comp if they're an independent contractor. So those are all things to think about. Okay, Sean?
Yes, I'm a retired person. So every
Okay.
once in a while the issue comes up. What about volunteering to help out? Is that something that can be done in a church office, or is that something that's not supposed to be done?
Yeah, no, if you're volunteering just to help out and, that's fine. And some churches only have a volunteer position, but I think churches need to look at, well, gee, is this person coming in every week and should I really give them, some compensation for that work? But a lot of times, a parishioner or somebody will just pitch in on a volunteer basis. They can say, no, I'm not coming in at any time. It's just like, hey, I'm doing this, out of the goodness of my heart and not because and I'm not coming in every week to do it. So, in the IRS, how did I go back to offer letter? Hang on. Sorry, I don't know how this got back. Oh, whoops, sorry. Sorry, I'm losing things here. Back to.
Thank you for that. That was
Yeah, sorry about that. Let me just go. I just want to make sure I'm getting back to where we are. Okay. All right. So those are all things, to think about. The IRS has its own little tests and they're basically the same. What's the control? What's the relationship? Okay, you've hired your person, you need to do an offer letter. There is a sample offer letter for lay employees. Clergy is a different issue. You will work with folks here to get a letter of agreement out. But for a lay employee, what are you going to put in the offer letter? Well, you want to put the basic job functions. If you have a job description, you can just refer to that and attach it to the letter. You want to, may want to tell them about the work environment, state your equal employment opportunity and non-discrimination policy, any contingencies to the offer. And a lot of times that's, contingent on you providing documentation to complete your I-9 form, for example, or contingent on a satisfactory background check. Required training, safe church, if they need to complete that. And then SHP is sexual harassment prevention training, which is required by the state of Connecticut. If you have fewer than 3 employees, you can just train your managers. I would suggest just train everybody. There's a free program, it's online, it's 2 hours, and it's offered through the Commission on Human Rights and Opportunities. You want to include that, hey, that we have at-will employment. This letter isn't a contract. Again, we can terminate the relationship at any time, and you can as well. And you want to provide, any policies that you have or handbook if you have it. One thing to be aware of is that employers are required to provide written notice to your employees at the time of hiring and annually thereafter of their entitlement to Connecticut family and medical leave, which, yes, does now apply to people with just 1 employee. And also the terms under which the leave can be used, as well as to their opportunity to take or to apply for the Connecticut paid leave program if they have a significant absence. And I'll go over that a little later in the program. All right, new hires. You have to have them complete the I-9, which is the immigration form. They have to provide original documents showing to you. You can't do this over Zoom or anything like you could during the pandemic. Form has been newly updated. It basically just includes all the information on 1 page and other things like if you have to re-verify or on separate pages. You need to have them complete the tax forms or state and federal W-4s. If you are offering benefits to them, any forms or information you need for that. If you are paying through direct deposit, the information that you need through that. Good idea to have them complete an emergency contact sheet, who to call if there's an issue. And also, if they're required to keep timesheets, how they do that. Do you have a timekeeping system, or just, kind of the paper timesheets they need to complete when they have to turn those in for to get paid for the week? It's always a good idea to have an orientation and onboarding kind of checklist. It helps remember when you're going through this process, okay, this is all the stuff I need to talk to this person about or give them, and then have them sign off on it so that you both have the understanding that you went through these things. Safety is important, show them the safety exits, the fire exits, what the fire alarm, where it's located, anything else, if you have a fire extinguisher, if you have an AED, where that equipment is located. This is something that a lot of employers are not aware of. If you haven't been doing it, don't worry about it, but try to do it going forward. But you're required to report within supposedly 20 days of when the person starts working. You're supposed to notify the Department of Labor. The purpose for this was basically so they could keep track of folks who maybe weren't abiding by their parental benefits and not paying child support. And all you need to do is send a copy of the first page of your Connecticut W-4 form that the employee fills out. There is a way to set up an account. It wasn't working last time I checked. So the easiest thing is to just fax it at that fax number, or to go to there's an address if you go to their website that you can mail it in. And personally, I make a note on the orientation form that I've done it. So again, just a reminder to myself, and also kind of a proof that I did do that. Job descriptions. Again, we have samples on the website. It should describe the essential functions, any educational requirements, any physical requirements. Like, for example, if you have a sexton that needs to lift or regularly do some physical things, outline that, and maybe explain that you will make reasonable accommodations for, and this abbreviation is, qualified individuals with disabilities. And you may not be able to, but you can include that statement. Always include that famous tagline, other duties as may be assigned, so that it's clear that, okay, this is generally what you're going to be doing, but there may be something else that comes up. A job description really promotes clarity as to what's expected, and it minimizes misunderstandings and assumptions. And frankly, it can be, if you wind up, unfortunately, having to discipline somebody for something they didn't do or weren't doing well, it gives you that, well, this was expected of you. We went over it in the job description, and you haven't been doing that. It's nice to have a standalone document, but you can also, just incorporate the job duties into an offer letter. And then I suggest review them periodically, because things change over time. If people take on new things, or somebody else comes in and takes away a duty and is doing something else. So you want to review them periodically, maybe once every year, once every 2 years, depending on, if things have changed. You'll also want to include, or you can include, whether it's part-time or full-time, usual hours of work. It could either be noted in the job description and or the offer letters to the employee. A quick thing on policies and handbooks. Handbooks are not required. It can be helpful because it gives you, a place where you have your policies, or at least have, some kind of binder with any key policies that you have. The pros of having one is that employees know the church's policies and procedures and the nature of the employment relationship. Again, the at-will employment and contract disclaimer, your anti-harassment policies, those are important, how to do timekeeping and attendance, any general workplace rules you may have, any statements against, violence, any safety program or plan you have, drug and alcohol policy, and time off and leave policies, and that includes the Connecticut FMLA. So even if you don't have a handbook, you're going to want to include at least these key policies, or communicate them with an offer letter, like salary, attendance, EEO and non-discrimination, and certainly the Connecticut FMLA and paid leave. And you want to make sure it's tailored to your workplace. Again, don't pull one off of the internet. It could not be one or use one from a former employer. It could be more than you need. It may include things that aren't even relevant or applicable to you. And, you know, I hope someday to get a kind of basic handbook up on our website. The ECCT handbook is on there right now, along with some just general policies. I do put the caveat in that we are in the process of updating our handbook. Although one thing that has been updated is the leave policies. And you may want to take a look at that, because when I get to the Connecticut leave and paid leave program, it's really confusing, and it's helpful to have a policy that kind of explains and how it integrates with anything else you may have, like a short-term disability plan. How does that work? It's also helpful that if you have a handbook or at least some policies, if you ever have to defend an administrative complaint or a legal action, hopefully you never do, but you can at least show like this is the policy and this person didn't comply with it. The general workplace rules, the wage and hour information, you know, a non-inclusive list of conduct that is not acceptable, use of church equipment. I do recommend a cybersecurity policy. If you are having a person use computers and whatnot, there is a sample on our website. Posters and notices, you all probably have to go out and build an annex to put these all up. I'm not going to go through these in detail, but these are all the different posters. I will say that they are available for free on the various websites for the agencies. The one for wage and hour is such tiny print. I always recommend that you get a mailed copy. The rest you could download. And there is an article on our website that goes through the required postings, and I believe it has links to most, if not all of these. And if you have a payroll service like Paychex and ADP or one of those, they often provide posters for free. You just want to make sure they're specific to Connecticut, not just, you know, the federal ones. There are companies who will try to sell you posters for like $100 or something, just some ridiculous amount. And they'll try to scare you and say, oh, there's been a big change and you know, you're out of compliance. Just ignore those. It's not worth it. And you're not, you know, again, you can get these for free if something has changed. If you do want to try to gather them all, you know, together, you don't have time to go pull them from all the websites. One place I do recommend if you want to order posters is the Connecticut Business and Industry Association. I'll put in a disclaimer, I worked for them years and years ago, but that's who I use to get my posters because I don't want to spend the time going through all this. Their rate for getting a set of posters is much less than these other shall we say, scammers who are trying to charge you a lot of money to get the posters. They also have a list of what is applicable, you know, to various sizes. So you get some posters you don't need to post, but you'll have that nice checklist. All right, sorry, I just missed that. Personnel and medical files. Connecticut actually has a definition of personnel files and what's supposed to be in it. And it does include application, you know, materials, any notices of compensation, anything that's been used to determine their eligibility for employment, promotion, additional compensation, termination, obviously any disciplinary actions, evaluations, reports relating to the employee's character, credit, and work habits, training records. It doesn't include medical files. Those should be separate. And medical files, I really just include anything that is medical related. So it'd be doctor's notes, leave or benefit forms that have medical information, and they should be kept separate from personnel files and in a confidential place. Both of these should be in like a locked cabinet in the rector's office, somewhere where people can't get into them. Just be aware that current and former employees do have a right to inspect their personnel files and make copies as appropriate. They should do it in your presence. It should be, there are limits. So current employee, you know, should make a written request for that. And for former employees, it got to be within a written request within 1 year of their termination of employment. If it's longer than that, you can turn it down. If you still have their file and want to be nice, you can provide it to them, but you don't have to. If there's any dispute over the contents, you can try to work that out. If you can't agree, the employee has the right to put in a statement saying, hey, I disagree with that in the personnel file. Also be aware that no individually identifiable information contained in a personnel file or medical records of an employee can be disclosed to anybody else not employed by you or affiliated by you, like a paycheck service, without written authorization of the employee, except where the information is limited to verification of the dates of employment. And again, it's a verification, the employee's title or position and their salary, although I'm always hesitant to do that without their permission. There are some exceptions, like if you need to disclose something because, you know, the person's having a medical issue and you're calling the EMTs, there are some exceptions for that. Break time. The only requirement is Connecticut is that you must offer a half an hour unpaid meal break for employees scheduled to work 7.5 hours, consecutive hours in a day. So you don't have to offer other breaks. You don't have to offer a meal break to somebody who's only working for 6 hours in a day. But you know, you can always do more than what's required. And most people do offer at least, you know, a 15-minute coffee break or whatever. The person, if they are working 7.5 hours, consecutive hours or more, can waive their meal period. They can say, hey, you know, I'm going to a doctor's appointment. I'm going to skip lunch today. But it's a good idea to get that in writing, even if they just shoot you an email, to establish that it's not that we made them do that, that it was offered. And as I mentioned, other breaks are not required, but are commonly given. Just be aware that breaks of 20 minutes or less do need to be paid. They are considered working time. Half an hour or longer don't have to be paid. Overtime, we talked about that. It's over 40 hours in a work week. There's not a requirement, unlike California, that if you work more than 8 hours in a day, you get, you know, have to pay overtime. It's actually worked above 40 hours per week. If they've taken a paid sick day, if there's been a holiday, that doesn't have to be counted as hours worked, but you should make that clear in a policy. One thing with non-exempt employees, you can't provide comp time in lieu of overtime. So you can't say, okay, well, you worked 10 extra hours this week, so next week, you know, you can have a comp day, take a day off. And you also can't average it like over 2 weeks. What you can do though, if somebody is like, say, works 2 hours late on Monday and they want to come in 2 hours late later on Wednesday, that's fine. It's just got to be within that same work week that you're adjusting the hours. You can require an employee to seek a supervisor's approval before they work overtime, but if they don't, you still need to pay them. So, you know, you can discipline them. Hey, you didn't get permission. And if it continues, that could be grounds for termination, but you do have to pay them. You're not required to provide paid vacation time, personal days, or paid holidays, or any certain number of paid holidays if you do offer some. It's really at the employer's discretion, though your policy should be clear. Connecticut does have a paid sick time law. It presently only applies for employers with 50 or more employees, and I'm guessing most of you don't have that. That may change though. There's been proposals in the legislature this year to change it down to 1 or more employees, so stay tuned, that may change. If you do offer any paid time off, you want to make sure your employees know the parameters, especially if you're offering it like on a pro rata basis to part-time employees, or if part-time employees aren't eligible, how long or, you know, the minimum way they can take is an hour at a time, half day. And have a policy regarding the how it accrues and the payout on termination. You're not required to pay out, you know, sick time and vacation time that was unused on termination. But the Department of Labor will follow whatever your policy or practice has been. So if you've normally been paying it out, you can't just say to this person that, you know, you just terminated, oh, and we're not going to pay you your vacation. Whatever your policy or practice is, you need to follow. Okay, this is probably the area of most confusion, And I do feel really badly for the small employers who never had to deal with this before. Because in Connecticut, where the Connecticut FMLA used to only apply to employers with 75 or more employees, and federal FMLA did and still does apply to employers with 50 or more employees. Now Connecticut FMLA applies to all employers. If you have one or more employees, you need to comply with this. And basically what it does is it provides for job protected leave for certain reasons, including the serious health condition of an employee or their family member, which is pretty broadly defined under Connecticut law. It also includes, childbirth, bonding with the child, and it can be up to 12 weeks. There's possibility of an extra 2 weeks if somebody's incapacitated during pregnancy. So if they have to go on bed rest and can't work at all, they would get an extra 2 weeks of that leave. It can also be taken intermittently or on a reduced schedule, meaning that, if somebody is maybe going for chemo treatments and they need to go every Friday, that could be their FMLA time. Or a reduced schedule. They need to leave, every Friday early for a particular appointment. That would be a reduced schedule. There are a lot of notices and forms required, including medical certification. Those are available from the Connecticut Department of Labor. We do have, and I highly recommend this to you, if you are in a situation where you think somebody needs FMLA, look on our website. I did an article when all these leaves came out, explaining both Connecticut FMLA and the Connecticut Paid Leave Program. And it may help you. And again, Connecticut FMLA only gives job protected time off. It has nothing to do with the compensation, because FMLA can generally be unpaid, although the employee might be eligible, depending on the circumstances, for Connecticut paid leave benefits. They may have disability benefits through the CPG plan if you subscribe to that, or if you have short-term disability. If it was a work-related injury, they may get compensation through workers' comp. So again, take a look on that. I also have, if you look at the ECCT handbook, as I mentioned, there is a whole leave section that has a sample policy and integration with other benefits. This is an area I got the most questions about this when I was in private practice. I still get probably the most questions on this here too. Now, the Connecticut Paid Leave Benefits is a separate program run by the state. It's funded by employee contribution through their payroll deduction. And this provides compensation, not a right to take leave. The employer decides whether the person is eligible to take leave. Although if Connecticut leave, family and medical leave applies, which it often does, then they would have their right to job protected leave through the FMLA. This is something the employee actually applies for. They go on the state paid leave website. They call it paid leave. It's, again, not a leave program. I tend to call it the paid benefits program or something, just to kind of distinguish it. But the employee applies. It's administered through AFLAC. You will, as an employer, get notice, though, not necessarily that somebody's filed a claim, although they're looking at changing that, but you will get employer notices because you're going to have to fill out information saying that, yeah, this person worked for me, here's what their salary is, and confirm all that. So you will at least know when somebody's applied. It's available when the employee can't work due to certain life events, including everything that's in the Connecticut FMLA. But there's also a domestic violence if they're the victim of domestic violence and need time off to tend to court proceedings or whatever. The tricky part is the integration with other benefit payments. The total should not exceed 100% of their regular compensation, but the paid leave authority will tell the employer, that's on you. You need to figure out what they're getting from us, figure out what disability they may have or anything else, so they're not getting more than 100% of compensation. One thing to think about, if you do have a disability plan or program, is it secondary to Connecticut paid leave? Meaning, paid leave pays first, and then maybe you make up the difference. So that's something to think about. And they will actually ask you on the employer form what other paid leave this person may get or be entitled to, and is it secondary to the Connecticut paid leave program and their benefits. All right. Other time off, you have to give a reasonable leave of absence for pregnancy-related disability. That includes childbirth. This usually is going to run concurrently with the FMLA because that's one of the categories that you can take FMLA for. But if for some reason the person isn't eligible for FMLA or they've used up all their FMLA time already, you still have to give them a reasonable leave of absence for pregnancy and childbirth related disability only, not bonding time. You have to give family violence leave if somebody's a victim of family violence, and that's up to 12 days of leave per calendar year for, the reasons related to family violence. Somebody's in the National Guard or in the military, National Guard can leave employment to participate in mandatory exercises or meetings. Military leave, there's a federal law that, says they can leave for military duty, and within a certain amount of time, they have reinstatement rights. Jury duty, yes, you need to give leave for jury duty, and for Connecticut, you have to compensate employees who regularly work 30 or more hours per week for their first 5 days of jury duty, although not on days if they regularly wouldn't work. They wouldn't normally work on Wednesday and they're on jury duty during Wednesday, you don't have to pay them for that day. There's crime victim leave if somebody's a victim and they have to comply with a subpoena or, participate as a witness to a crime, attend a court proceeding, then that leave is required to be given. Bereavement's not required, although a lot of employers do offer at least a couple of days of paid bereavement leave. But again, you could also ask that people use their PTO if you're offering that, to make it separate. A personal or administrative leave is not required, but sometimes you have situations where, maybe somebody's seriously ill and they've used up all their other time and you're sympathetic and you want to give them a little more time off. You can have a personal or administrative leave. The person may be inactive, they may not be getting paid. If you're going to do that, though, I would set out some parameters on that, like they have to have exhausted all their other paid time off, when they have to report back, is it in your discretion to decide how long they're going to be out. All right, I'm going to quickly go through performance. Evaluations are not required. It's a good idea to do them. Usually if people do them, they do it annually, but if you have a new employee, you may want to have an earlier review, like after 60 days or 90 days to see how they're doing. And my thing with performance is it really should not be a surprise. You should be giving feedback, throughout the year. And if there are issues, address them, not wait till, oh, we're doing our performance evaluation in 6 months. I'm going to wait and deal with that then. You want to deal with it right away and have ongoing discussions about performance. And it's just a good idea that it gives you the feedback right away. Set some time to, if you don't have a formal evaluation process, to meet with the employee and review their performance periodically. One thing to know, there are legal requirements regarding accessing copies and language that should be included, not only in performance evaluations, but in disciplinary actions, that the employee has the right to submit a written statement if they disagree. And you need to provide them with a copy of the evaluation or the disciplinary action within 1 business day of them getting it. The thing about employees being able to submit a written statement is not new. That's been on the books for a while. What is newer is that you have to actually include a notice about that in your forms. Again, there are some samples on our website that does have that language. I'm going to kind of skip through this a bit. Kind of just what's helpful to include in any kind of performance evaluation or discussing things. Evaluations often go wrong where there aren't clearly defined standards. There isn't a factual record of what's been going on, like an attendance issue, for example, and you haven't really kept track. I think people are afraid sometimes that, oh, I'm going to hurt their feelings, they're going to leave, there's going to be a problem, and they don't do an evaluation. Or they tend to do the central or average tendency. Well, generally they're okay, so I'm not going to give them, really say anything bad. The halo or horn effect is you just remember what the most recent thing is, like, oh, they did that awesome project. So yeah, excellent. Or horn is well, they did a really bad job last week. So negative, negative, negative. You want to look over whatever time period it is. And just think about, do I have any biases? We all have them. Is it affecting the evaluation process? Counseling and coaching is a way to address performance behaviors. It's not as formal as an evaluation, although I think it's helpful to have any counseling or coaching session to note it, maybe a follow-up email, at least a note maybe in your calendar or something, because if there's no improvement, you may need to take more formal steps to address it, and that lets you go back and say, well, as we discussed on March 15th or in the middle of March, whatever it is, your attendance has not been great. You were supposed to improve it and you haven't. Now I'm going to the next step of maybe a verbal or written warning or performance improvement plan. Steps can be as serious as suspension or termination, although usually if it's a performance issue, you're going to want to have some record of discussing it and talking about it before you terminate somebody. I would say the immediate termination is really for something serious. You found they were embezzling or they made a threat of violence against a coworker, that kind of thing. Verbal and written warnings, you want to make sure that they clearly address the issue, refer to prior conversations, as I mentioned. You do want to give them a chance to be heard. You have to agree with them, but, let them know you understand their position, but there's still, hey, we have these expectations. And again, even a verbal warning, it sounds kind of contradictory, but it should be documented. Performance improvement plans are really to give somebody feedback, but specific steps. And it's usually preceded by a counseling or maybe a warning about the deficiency. Set a time period, although make it clear that, hey, it's still at will employment, and we may be giving you a 90-day performance improvement plan. But if things don't improve, we still have the right to terminate it early. On documenting, you want to be specific, keep it fact-based as much as possible and not subjective. I would say, sometimes people want to put down, this person's like the laziest employee I've ever seen. No, you want to keep it fact-based. We expected them to complete the directory, within a month, and, they just have not done that. And it's 6 months later. You want to be timely with your documentation because memories do fade over time. And if it's something where improvement is needed, to include that. So just be careful with, how you're documenting and making sure you do document. As I mentioned, any performance evaluation has to have that advisory that they can submit a written statement, which has to be kept in their personnel file. And if they ask for their evaluation, for example, a copy of it, it should be included as well. And ensure that any performance reviews or disciplinary documents are put in the personnel file. Sometimes, the supervisor will just throw it in a desk drawer and forget about it. No, make sure it gets into the personnel file. Termination of employment. Is it a voluntary termination or involuntary? Even if somebody's voluntarily leaving, hey, I'm retiring, I'm gonna go take another job, it's always a good idea to have them submit a resignation letter. If you give a termination notice, again, it has to include that language in it. Think about the final pay. For a voluntary resignation or a layoff where, hey, financial circumstances, we can't keep this position anymore. They need to be paid on the next regularly scheduled payday. But if you're terminating somebody, say for a performance issue or something like that, they need to have their final pay by the next business day. So it's a tighter requirement. Think about if they've been participating in a benefits plan, when do benefits terminate? If they're on the medical plan, maybe it doesn't terminate until the end of the month. If they're, leave mid-month. If they may have a right to continuation benefits. Often it's going to be the provider, whether it's CPG or Aflac or whoever's administering it, that sends out that notice. But let them know, oh, you have the right to continue benefits, health benefits. You should be receiving notice, shortly from that. We don't generally participate in unemployment compensation. If you do opt in to participate in the unemployment compensation program, explain you have to fill out the form and let them know they can file for unemployment comp. You're not required to provide severance, but I think, sometimes when you're not participating in unemployment compensation, maybe it's nice to include, a week or two of pay. Also think about if you are paying severance, especially if it's above and beyond, whether you want to have a waiver of claims for the employee. If you're in that mode where you're thinking, I want to have a waiver, please talk to counsel. There are very specific things that need to be included in a waiver for it to be valid. Make sure your employee returns all property, keys. They're on the computer system or your email from off of that access. Again, a checklist can be helpful in this regard. That's all I have. We got through it. So I apologize, some slides I may have gone through a little quickly. So if you do have any questions, please let me know. I'm going to put up, some of the resources that are available to you, not only our website or just giving me a call or an email. You may have an HR consultant. Sometimes payroll companies will help. Or you may have counsel, a legal counsel, especially if you've got a legal claim. If you call me about that, I'd probably mind you referring out because, again, our conversations are not privileged. And, sometimes it might be somebody within the parish that can help out with this. You can go to the state of Connecticut and in cases federal websites like the Department of Labor, the Connecticut Paid Leave Program, the Commission on Human Rights and Opportunities. You have good information on their websites that might be helpful to you. You can also look to human resources organizations. If you are a larger parish, maybe it's worth joining the Society for Human Resources Management. That one's a few $100s a year to join. There are local chapters as well. The one I belong to is the Human Resources Association of Central Connecticut. There are others throughout the state, and I do believe you can join the local chapters without having to join the National Society for Human Resources Management. The Connecticut Business and Industry Association also has some good materials on their website because they are, often counseling their members on human resources issues. And I believe a lot of that stuff on their website is free. For others, it might be limited to members. All right, that's it. Now let me see if I can get out of this. And I'm going to hang on just a second and try to show you. Okay. Let's see if I can do this. Just want to show you on our website where you can find that information. All right, let me go back. All right, please share my screen again. All right, can you guys all see that? Our website. This is the homepage. If you scroll down under resources, there's parish administration. And you have to scroll down a bit more, but there's the human resources section. And you can see there's articles on HR topics, stuff about the background check, the latest minimum wage that went through, the employment posters. There's a copy of the new I-9 form. Some of the notices are there. So there's a lot of good information there. And there's also some policies, There's, again, I would be a little cautious using our handbook right now, but there's a sample cybersecurity policy, there's the sample EEO policy. Obviously you need to fill in your names and the information that applies for you, but this does include the current list of all the things protected under state and federal law. And let's see what else I can show you. Hang on a second. Need to close out of this, and it's hard to do. Let's see. All right, so there are a lot of resources there, and I do encourage you to take a look at that. Are there any other questions that anyone has? I'm sorry, it was a lot of information and kind of a very short time. Stephen has a question. Stephen, just unmute yourself and ask away.
I'm the priest in charge.
Hang on a second, it's really hard to hear you on my end. Let me try.
Can't hear me?
Okay, try again.
Yeah, hi, can you hear me?
Good. Yeah, I had to turn my volume way up.
Oh, okay, I don't know, I'm right next to my computer. I'm sorry.
No, that's okay.
So I'm the priest in charge in Roxbury, Christ Church Roxbury. And
Okay.
this is awesome. I mean,
thank you.
Really knowledgeable, you communicate it well and clearly. And of course, we all know that there's sort of an elephant in this living room. And that is that, and I can use our church as an example. I am a half-time clergy person. We have a part-time music minister. And it simply is impossible for us as a parish to actually follow all of these rules. We do our best. We cannot take up an entire bulletin board full of notices. And so there's no solution here. It's simply the way that it works. The only solution would be to have some kind of a pooled resource in either a network of parishes, which I think we call a diocese. And that's not going to happen tomorrow. I'm just lifting that up because I did see at least one other comment in the chat about this. So,
I mean, what are you envisioning with that? Because we do try to provide resources like this and the ones I showed you, and you guys can call me. What would you be looking for in that?
Well, it's great. You provide a huge amount of resources on the website, and you provide things like this, and you are always available. I think I may have reached out to you once or twice. And that said, we are still in a mode of small churches who have one quarter-time employee or whatever,
right,
being on our own to actually all the administrative work.
Right.
We simply are not able to do that. So we do our best. We pray. We make judgment calls, and that's how it gets done.
Right.
We got to the point where somebody wanted to make a stink about, in a parish environment where something goes south and some form wasn't posted or things weren't done in a correct way.
Right. Yeah, I mean, it's always an assessment of risk. And, I'd say some things are probably more important than others in terms of how much risk you're facing. I would try to get the basic employment posters up because that does have information for your employees and they can look to that. In making sure your timekeeping, if you have employees that are keeping their time, that it is accurate, they're doing it, you're paying on time, that's very critical because it's also the one that's probably going to lead to a complaint if you're not doing it. And that's part of the risk. If somebody goes to the Department of Labor, they'll be like, oh, okay, they may come in. And then when they come in, they're not necessarily going to limit it just to the compensation issue. But they will give you, if for some reason there's an error in pay or something, for example, most of the time you hope your employee is going to say something. And then you would just work it out, oh, okay, we missed an hour of time last week, we'll pay you for that, and so, a lot of times there's room for that kind of discussion before it ever gets to the level of somebody running to the Department of Labor and filing a complaint. And a lot of this stuff is free and freely available. So, if you are, I would do an offer letter to people just so you have those parameters. That's pretty important. And again, there are samples that you can adapt on our website, and I'm thinking I may jump into one of those Wednesday morning calls and show people, because I think a lot of people don't realize it's there.
We actually have some of your models. We recently rationalized a long-term employment relationship that had been undocumented, and it's documented. We utilize diocesan resources, and I'm very grateful for the support of the vestry. Our senior warden is on this call as well. I'm going to call her out, Donna. And it is, as you suggest, why you can't officially say that. It does ultimately come down to a real world of trying to make trade-offs and what are the priorities, and act in a way that is ethical and as right as possible, given that two of us having already spent a total of 3 hours of our time in a call like this is about all we're going to be able to give to HR stuff for a while.
Right. And my point too in doing this is kind of make you aware of some things and sort of the traps that sometimes people get caught in. And especially the other thing I would mention that I think is very important and new to employers is that whole paid leave and FMLA, and knowing that if sometimes just being aware, that somebody comes to you and they've like, oh, I'm having surgery next week, I'm going to be out for a week or two, just having that red flag go up. Okay, that's probably Connecticut FMLA. I should give them a notice and a medical form so I know how long they're going to be out. And if I don't have payment for them, that they can go to the Connecticut paid leave. And that's what the posters also do. They have that information for employees. So I think those things are very important, making sure your employees know, and the offer letter is a good place to do this, when they're getting paid, their hours of work, all that stuff is very important, how they're going to keep their time, that it's supposed to be accurate. And having some of the basic policies like the EEO policy, anything, how they're keeping their time, basic policies like that. I would look at the leave policy in our handbook and think about how you would integrate, any leave that they have, and provide that to them. So at least they have the notice and know, okay, if I'm going to be out for a while, or if my dad is really sick and I need to care for them, I have this benefit available to me. So I do think that's important. And, I could see somebody, if they didn't get the leave or the benefits they felt they were entitled to, I think that's another place of risk where they could maybe complain about that. All right, Shaw.
Yes, I think some of the things that you've been talking about pertain to full-time employees versus part-time, because I think the situation that was just described to us of two part-time employees. So some of those things wouldn't apply simply because of the number of hours that people are working. And I think it's helpful to make a distinction, because there are a lot of quarter-time clergy. I used to be a quarter-time clergy, and so and retirement, maximum time is less than half time. If I go to quarter time, that's like 10 hours a week. That includes everything. So I would not necessarily be under A, I'm in retirement, but also B, that wouldn't require a lot of things that you've mentioned, simply because they're designed for full-time employees. Am I correct on that?
Be careful with that, because Connecticut FMLA, for example, there really is no minimum hours requirement. The only requirement is that you need to have been there 3 months or more. So unlike, again, I think you're probably thinking of, certainly under the federal FMLA, for example, there were requirements. You had to work, 1,000 hours, and there were things like that. But Connecticut is very liberal with things like that. The keeping track of your hours and all that. that would still apply, even to part-time employees. Giving the information on that stuff as well, the posting requirements. But yeah, things like benefits, it may not apply to part-time employees. They may not meet, the 1,000 hours it needed for pension, or or you may not even offer those benefits, or maybe you offer vacation to your full-time employees, but not to your part-time employees, and that's fine. So there are things certainly that, really won't affect or apply to part-time employees. Like you look at the overtime, for example, probably if you have a part-time employee, they're never going to hit the 40 hours a week, that they're eligible for overtime. But if they're non-exempt, they are. And for some reason, you have a great gala or something and they work for 40 hours or more, and they would be entitled to that. So it may not affect people, but there are still things that apply. And again, Connecticut, we're not as, employee intense as, say, California, but we are one of the states that is a lot more generous, in terms of what is available to employees.
Okay, thank you.
Mm-hmm. All right. Anybody else? Yes. Is it Donna or Donna?
It's Donna.
Okay.
And Reverend Stephen is our half-time priest in charge in Roxbury. And thank goodness for his business background, because he's been an enormous help in helping us try to get on board with things being done correctly. And as a small church with volunteer office administration and our two part-time employees, which is our priest. And I have to say that when it comes to hiring a priest, the diocese is very specific. They come up with the agreement, they come up with all the steps, what to do. The other person is our music director, or our minister of music. And but what I would like to see, I guess, is not so much as to add to all of this volunteer time, the do-it-yourself of having to go to the website and research all of this stuff, that maybe when something changes or something's new or there's a new statute, that either you, Jean, have a little spot in the newsletter that goes out saying, hey, we've got some new stuff, here it is, here it is, or an email out to the parishes, because there's more and more small parishes like ours that are working with limited numbers of people with not excessive knowledge about all of these things. So I think more communication on that basis might be very helpful.
Okay. When I do write like an article, like for example, the minimum wage, when it went up, that is included in our e-news, and sometimes also in the Mission Matters, which comes out quarterly. So you'll always see if I've done something new that I've posted, it will be in that. And often I jump on the Wednesday morning calls as well. And we'll just, like, I know I mentioned, when minimum wage went up, for example, because that does affect some people that just have like the part-time employees that are paying minimum wage. So we do try to do that. And as I said, maybe I'll jump on one of the calls and kind of do what Gigi did last week and go through the website and show people where their things are. We're also striving to improve the website so things are, more easily found. And hopefully that you can search, like if you have an issue, like, oh, gee, I need to do an offer letter, that when you go to resources, you could put in offer and it should pop up. So, I hope that's helpful. We do try to get the word out when there's a significant change, like when the paid leave came out. We did do an article on that and talked about that as well. And it was in e-news for, I think, a couple weeks actually. So, but maybe we need to send it out again, so.
Thank you.
I appreciate the input though, I really do. All right, anyone else? All right, great. Well, thank you all for participating. This should be online with our spring training and gathering along with the other presentations if you need it. And if I can be of help to you at all, if you have an issue or a question, please reach out to me. And I'm happy to help you out as best I can.
Sounds good. Thanks, Jane.
All right, take care. Have a great day.
Thank you.
Bye.